The methods below show how to stop an eviction after a court order. There are several ways to accomplish this task. Remember, no method will stop an eviction forever, but pausing an eviction for a time will allow you certain benefits, like saving up money to pay the rent balance in full, or saving up money to get a new rental unit smoothly. Those are very worthwhile goals to achieve. Can you stop an eviction after court? Yes, it is often possible. The real problem is that a judge has already given a judgment of eviction to the landlord. However, sometimes you were not there, as a tenant, to defend yourself. This is called a default judgment of eviction. Other times, you were there at court and lost your side of the case. This is completely normal. Most of the time, if the issue is non-payment of rent, then unless the rent is paid, the landlord will win. But you can delay the eviction process and buy some time. Let's get to it. How to stop an eviction after a court hearing. File Chapter 7 Bankruptcy. This strategy works best when living in the handful of states that allow a bankruptcy to stop an eviction after a judgment of eviction has been rendered. However, with that said, many judges have honored the bankruptcy filing for 30 to 60 days even though they didn't have to. So, if this strategy is something that you would like to try, make sure you have a firm plan B. File Chapter 13 Bankruptcy. The same as the Chapter 7 bankruptcy above. There are a few states that allow a bankruptcy to stop an eviction for at least 30 days. After the 30 days, the rent monies would need to be deposited with the bankruptcy court to continue to stay the eviction. But those 30 days may be just the 30 days you need to pay the rent. That will usually equal 2 to 4 paychecks. Appeal the judgment. The appeal process takes the case to a higher court. This is useful when there is evidence to present that was either missed in the first hearing, or when there was a default judgment issued on the first hearing. An appeal is usually the cleanest, fastest way to add some time to the eviction process. However, this method requires some special understanding of the court process at your local county court. It is possible, but only for those people who know their local court very well. Usually it is best to hire a lawyer to do this. But what happens if you don't have the money for a lawyer? The next best option is to use a stop eviction service, local or online, to help with the paperwork to do these types of things. An appeal is usually well within their skill set. These stop eviction places help thousands of people a year to stop their eviction. Ask the judge to reconsider. This is much like an appeal, except the case isn't going to a higher court. The eviction case stays with the original judge. The paperwork for this is usually best left to a local attorney. But if the attorney is too expensive, then a stop eviction service would be the next best choice here too. Fix the problem with the landlords. Sometimes the eviction is for non-payment of rent. In that case, only the rent can fix the problem with the landlord. Yet, other times, the eviction is for something else: pets on the premises, loud music, extra people living in the unit, etc. In these cases, sometimes if you talk with the landlord and fix the problem, the landlord will drop the eviction. Remember, they usually just want steady rent coming in. And if you are nice, they sometimes are nice in return. So, is it possible to stop an eviction after a court judgment? Yes. If you are facing a sheriff notice of eviction and you haven't had your day in court, get moving. Today is the day to make that happen. Most county courts don't give a lot of time to take action. The landlord is waiting for their rental unit to be able to rent it again. If you take action and move quickly, you can in many instances stop an eviction after the court judgment.